Thank you, Mr. Speaker. I really haven't ever become friends with General Michael Flynn. He doesn't object to being called Michael Flynn, even though he earned the title of general, even though he has not been treated fairly at all, has actually been treated unjustly. There's an article today from Margot Cleveland in the Federalist, and it talks about Michael Flynn's case, and I'm learning some things. I think the world of Sidney Powell. She's an amazing attorney. She is a friend. But there is a motion pending before federal judge Emmett Sullivan on a motion to compel, motion for sanctions that attorney Sidney Powell had filed. Sidney Powell's motion seeks to force federal prosecutors to provide Flynn an array of documents withheld from his attorneys and to sanction government lawyers for their failure to provide relevant evidence to the defense team in a timely manner. Now, as a former judge, and I've prosecuted, I've defended, I've been a Chief Justice, but nothing is more infuriating to me than when it comes to our justice system than prosecutors who are unjust, who lie, who misrepresent. And it looks like all of that has been occurring in Michael Flynn's case, or with deference to, like Colonel Vindman, General Michael Flynn. But mere days, this article points out, mere days after the final briefing came in to Judge Sullivan, federal prosecutors found themselves forced to admit that for nearly 3 years they had wrongly identified the authors of the handwritten notes taken by FBI agents during their January 24th, 2017 interview of then National Security Advisor Flynn. Prosecutors had told defense counsel and the court that the notes written by Peter Strzok had been compiled by FBI agent Joe Pietka, and those taken by Pietka had been written by Strzok. This embarrassing mea culpa surely added strength to Powell's plea for access to other withheld information. After all, if federal prosecutors made such a basic blunder concerning key evidence, what other mistakes lay buried in their undisclosed evidence? This goes on and points out that at a minimum, things that are being set out now would also support the withdrawal of Flynn's guilty plea, something Powell does not appear to be considering at this time, including, and here's the circumstances, it's just phenomenal, that in a federal district court, we could have Justice Department attorneys who are this flagrantly abusive of the process. So Flynn's original attorneys had a conflict of interest preventing them from representing Flynn in the criminal case. Flynn did not intentionally make false statements to the FBI agents. The FBI agents entrapped Flynn. Flynn's purported misstatements were immaterial to the investigation into supposed Russia collusion, and thus no crime occurred. The government engaged in selective prosecution and charged Flynn solely because of his relationship to Trump. Prosecutors used threats to induce Flynn's plea. The prosecutors failure to timely disclose exculpatory and impeachment evidence invalidates Flynn's plea, and that egregious prosecutorial and government misconduct mandates dismissal of all charges against Flynn. You go on further, more revelations. The government had pushed Flynn's previous attorneys at Covington and Burling in February 2017 to quickly file a registration statement under the Foreign Agent Registration Act, FARA. For Flynn Intel Group, FIG, federal prosecutors later obtained indictments against Flynn's FIG business partners for supposed Foreign Agent Registration Act violations, and still later, the prosecutors branded Flynn a co-conspirator in that case. There was a clear conflict of interest which the government failed to mention to Judge Sullivan. Since Flynn last appeared before Judge Sullivan, the government's FARA case against his FIG partners has imploded. Following a 6-day trial, a jury had convicted Flynn's former business partner, Bijan Rafkin, of acting as an unregistered agent of Turkey, conspiring to act as an unregistered agent of Turkey. But it says federal judge Anthony Trenga stepped in, tossed the guilty verdict, concluding that no, quote, rational jury could conclude that Rafkin conspired with Alptekin or anyone else, unquote. Judge Trenga further held that, quote, there is no evidence of discussions or suggestions, let alone any agreement, express or implied, to either avoid filing under FARA or to cause the filing of a false FARA registration statement. That the government's FARA case against Flynn's business partner proved bogus should also trouble Sullivan because, according to Powell, earlier court filings, the special counsel's office had informed Flynn's counsel in the summer of 2017 that it was going to indict the FARA case, then had obtained authorization to target Michael Flynn Jr., who had just had a newborn, and seized all of his electronic advices. The threat was clear: plead guilty or cooperate, or we will prosecute your son. And given Judge Trenga's conclusion in the Rafkin case, there was no evidence of a FARA crime. There is added postscript: we will prosecute your son on bogus charges. Unbelievable. Just unbelievable. And it also should be quite scary to someone situated as Michael Flynn, General Flynn, that the federal government, the DOJ, especially when they use unscrupulous and unethical means, they can convict anybody even when there is no evidence whatsoever. As Judge Trenga found, there was no evidence whatsoever. I don't know these people, but I know the federal judge said there was no evidence whatsoever, and yet the jury came back. I'm sure the judge was just thinking, I'll let the jury find there's no evidence because there is none. And when they came back and convicted, wow, the judge is going, I got to throw this out. This is totally bogus. So the threat was not a one-off. After Powell took over representation of Flynn, federal prosecutors attempted to force Flynn to testify at Rafkin's trial that Flynn had knowingly made false statements in the FARA filings, which is something Flynn denies. When Flynn refused to lie, federal prosecutors abruptly added Michael Flynn Jr. to the witness list for the Rafkin trial, but then never called him. Total intimidation, total effort to intimidate. Very unethical. The government, according to Powell, also had an FBI agent contact Flynn Jr. directly, even though the younger Flynn was represented by counsel. Also quite unethical. Boy, the unethical conduct in this Department of Justice hadn't gone away. It hadn't stopped with Strzok and Page being gone, Bruce Orr, all of these others that appeared to conspire to defeat a presidential candidate and then to try the coup to take him out. But the government, according to Powell, also had an FBI agent contact Flynn Jr. directly. These maneuvers corroborate the prosecutor's earlier use of Flynn Jr. as a pawn to pressure his father to plead guilty. I mean, this stuff is just amazing. And if they can do this to someone who spent over 30 years dedicated to the defense of his country, all kinds of decorations for heroism, and powerful friends in Washington, they can do this to him. It's difficult to think about the terrible situation of someone without money, without friends. If these people can be this unscrupulous to people with some power, it just bodes very poorly for this little experiment in self-government when the judicial branch, the executive branch's prosecutorial wing is this abusive. Absolutely incredible. A bit frightening, actually. So I would like to also touch on some of the testimony that's gone on. In yesterday's hearing, where the part where we had Jennifer Williams and Lieutenant Colonel Vindman, he said, I think he's been in over 20 years, didn't make colonel. And I've known people, my 4 years in the Army, we saw those folks. They were so self-righteous. On the one hand, maybe they didn't get a promotion they thought they deserved. Maybe it was because they did something like Vindman did and was trashing the United States to Russians when he was overheard by a superior that reprimanded him for it. Sometimes it's just because there's a mean superior that doesn't want somebody promoted, but for whatever reason, he didn't become a full colonel. Here he is harping after he'd been called lieutenant colonel over and over by my friend Devin Nunes. He erupts and demands, and I noticed that he doesn't always call people congressmen. That doesn't bother me, but it's just quite interesting that he has such a double standard for himself and for others. But when you look at the testimony, especially page 2, it's interesting. And actually, this is from our friend Adam Schiff, Congressman Adam Schiff. Colonel Vindman, we've seen, and I guess it should have been Lieutenant Colonel Vindman, we've seen far more scurrilous attacks on your character and watched as certain personalities on Fox have questioned your loyalty. I note you've shed blood for America, and we owe you an immense debt of gratitude. So if that's the case, we owe him a debt of gratitude for defending our country. I do love history, and I point out down the hall when we're in the rotunda to groups, we got General Gates standing there accepting surrender from the British, and he was not the real hero of the Battle of Saratoga, and that was the biggest victory since December 24, 1776, probably. And it was a big one, but it wasn't Gates. I read another book on the Revolution just months ago, and this book was saying Gates never got out of his tent, whether it was cowardice or whatever. He never would get out of his tent, but there was this great, brave, courageous young major that just knew that they could defeat the British there at Saratoga if they get on going and attack them. Gates wouldn't give the order, so this major rallied folks, and they went down and they attacked the British, and they defeated them. So the real hero of Saratoga wasn't General Gates. It was this major, tough, strapping guy, he took him on, and he was wounded, and he carried a limp with him probably the rest of his life. He was wounded. He was hurt severely. But we owe that guy a debt of gratitude for his defense of his country. Of course, later on, he got upset that he had been slighted and didn't get a promotion like Gates's immediate subordinates, and then that caused him to fall prey to British talking to him to helping them because they would pay him and they would appreciate him a whole lot more than Washington and others. And of course, then he ended up setting up Washington to be kidnapped by the British. But I'm amazed how many people don't know that we owe a great debt of gratitude to Major Benedict Arnold, because without him, there's no victory at the Battle of Saratoga. And that was a huge victory, so very important to our becoming an independent country. So anyway, just interesting when you think about history and people that demand to be given respect, and if they're not, they get rather snippy. And I don't know that I've ever met Lieutenant Colonel Vindman, but to find out that he was trashing the United States to Russians, and it was just intriguing to go through his testimony. And for example, he said that the investigation into the 2016 elections, Biden's, Burisma, I stated to Ambassador Sondland that this was inappropriate, had nothing to do with national security. Following the meeting, Dr. Hill and I agreed to report the incident to NSC's lead counsel. So it's interesting. On over further, he was asked by Mr. Goldman on September 10th. The Intelligence Committee requested the whistleblower complaint from the Department of National Intelligence. He wasn't aware of that, but it's just, wow. So September 10th, they obviously knew all about the so-called whistleblower complaint. But when you get over here to part of the questioning by Congressman Nunes, did you ask or encourage any individual to share the substance of the July 25th phone call or any matter associated with the call with any member of the press? I did not. And he goes on like that. But he said, Lieutenant Colonel Vindman, did you discuss the July 25th phone call with anyone outside the White House on July 25th or the 26th, and if so, with whom? And he said, yes, I did. My core function is to coordinate U.S. government policy, interagency policy, and I spoke to two individuals with regard to providing some sort of readout of the call. Nunes says, two individuals that were not in the White House. Vindman, not in the White House, and that's Lieutenant Colonel Vindman, not in the White House, cleared U.S. government officials with appropriate need to know. And what agencies were these officials with? Colonel Vindman, Lieutenant Colonel Vindman said Department of State, Department of State Deputy Assistant Secretary George Kent, who was responsible for the portfolio Eastern Europe, including Ukraine, and an individual from the Office of Intelligence Community. And that is where Nunes said, as you know, the intelligence community has 17 different agencies. What agency was this individual from? And that's when Chairman Schiff said, if I could interject, we don't want to use these proceedings, and then crosstalk, we need to protect the whistleblower. And it's really interesting. Of course, this is when he calls out Congressman Nunes, it's Lieutenant Colonel Vindman, please. So I want to make sure that I don't slide him. He says and he's under oath. I don't know who the whistleblower is. That is correct. And yet, he gets down to there's two people. He identifies one, and Chairman Schiff interrupts and doesn't want him to out the other person because that would be outing the whistleblower. And yet, Chairman Schiff and Lieutenant Colonel Vindman say they don't know who the whistleblower is, but must be that one that he's told not to answer because that would give away the whistleblower's identity. And yet they say, we don't know who the whistleblower is, but we're down to one person, but we don't know who it is, even though if he gives the name, it'll out the whistleblower. It's just really amazing when you look at this stuff. And actually rather tragic. And there was a question, Mr. Castor says, and you were aware, George Kent testified a little bit about this last week, that under the Obama administration, the U.S. government encouraged Ukraine to investigate whether Zlochevsky used his government position to grant himself a Burisma exploration license. Are you aware of that? And Lieutenant Colonel Vindman said, I would defer to George Kent. He's found knowledge on Ukraine much deeper than I, and if he attests to that, then I'd take his word for it. Well, isn't it interesting that Mr. Kent knew that the Obama administration was trying to get to the bottom of corruption about Burisma, and yet he freaks out, not Kent, but Mr. Lieutenant Colonel Vindman freaks out over Burisma being brought up, that's some kind of crime for an impeachable offense, basically, for President Trump to bring up the corruption and including Burisma. But isn't that interesting? He doesn't bring up there's a problem with the Obama administration bringing it up, just President Trump. But Ranking Member Nunes also brings up that I asked Ms. Williams about this, about if she had ever accessed without authorization fellow employees' computers. She answered no, and he goes on through some of that. But you get down here, and then it's turned over to Jim Jordan. Congressman Jordan said, Mr. Morrison said this, quote, I had concerns about Lieutenant Colonel Vindman's judgment among the discussions I had with Dr. Hill, that's Fiona Hill, and the transition was our team, its strength, its weaknesses, and Fiona and others had raised concern about Alex's, he should have said Lieutenant Colonel Vindman's judgment. When Mr. Morrison was asked by Mr. Castor, did anyone ever bring concerns to you that they believe Colonel Vindman may have leaked something? Mr. Morrison replied, yes. They thought he was a leaker well before this all happened. So your boss had concerns about your judgment. Your favorite boss, Dr. Hill, had concerns about your judgment. Your colleagues had concerns about your judgment. And your colleagues felt that there were times when you leaked information. Any idea where they might have gotten those impressions? Colonel Vindman, he calls him Colonel, he gave him promotion. But Vindman says yes, and then he reads an OER that was somewhat glowing. But actually, the answer should have been no if he was being truthful, because he later says, I can't say why Mr. Morrison questioned my judgment. But Congressman Jordan goes on, Colonel, it's interesting, we deposed a lot of people in the bunker in the basement of the Capitol over the last several weeks, but of all those depositions, only 3 of the individuals we deposed were actually on the now somewhat famous July 24th or 25th phone call between President Trump and President Zelensky. There was you, individual sitting beside you, Ms. Williams, and there were, of course, your boss, Mr. Morrison. When we asked Ms. Williams who she spoke to after the call about the call, she was willing to answer our question, and Chairman Schiff allowed her to answer her questions. When we asked Mr. Morrison who he spoke to after the call about the call, he was willing to answer our question. Mr. Schiff allowed. chairmanship allowed him to answer our questions. But when we asked you, you first told us 3 individuals at the NSC, your brother and 2 lawyers, and then you said there was a group of other people you communicated with, but you would only give us 1 individual in that group, Secretary Kent. Chairman would only allow you to give us that name. When we asked you who else you communicated with, you would not tell us. So what I want to know first is how many other people are in that group of people you communicated with outside the 4 individuals just named. Mr. Jordan, on a call readout, this has been Lieutenant Colonel Vindman, on a call readout, certainly after the first call, there was probably half a dozen more that I read out. Those are people with proper clearance and need to know. In this case, because of the sensitivity of the call, Mr. Eisenberg told me not to speak to anybody else. I only read out, outside the NSC, 2 individuals. So very interesting there. And it is interesting, too, that, the fact is, if Lieutenant Colonel Vindman, say hypothetically, he leaked as he had been suspected of in other cases, say he leaked in this case to people that didn't have proper clearance, he probably would try to assert, I was named as a whistleblower, and once I had that status, you can't prosecute me. And then there would be a motion to dismiss, this kind of thing. And ultimately, the courts would say, wait a minute, the whistleblower statute does not protect the whistleblower, because to protect a whistleblower, you have to be within, or the person being complained about has to be within the department or agency from the person complaining. The president's not in the intel agencies or department. And so it just wouldn't work. And of course, previously you had to have direct knowledge. And we would submit, I would submit, if you look, it's treason is something the president can be impeached for, but under the Constitution that requires 2 people with direct knowledge and as direct witnesses, not hearsay, can't be hearsay, direct witnesses to a crime. They have to testify. If you don't have 2, you can't prove treason under the Constitution, it's out. And I would submit the Senate would do well if this is sent down there to require the same thing of whatever bogus charge ends up coming their way, because that's all we've seen so far, but require 2 people with direct evidence. A bunch of people have been convicted of treason. No president's ever been removed. So if we're going to remove a president, it ought to require 2 direct witnesses as well. And so it ought to be a short trial. So with that, I yield back.